May it please the Court, Brett Feinstein on behalf of the appellant, Aventura Management. I would respectfully request that I reserve 2 minutes for rebuttal.
All right.
For an issue so important to the condominium world, the world of condominiums, associations, and purchasers alike, even tenants, this issue that is before you boils down to one very simple point: ownership of real property. The statute 718.116 sub 1 sub A says it applies to a unit owner. The statutes further go on to define a unit owner as a condominium association. It says it applies specifically to all owners, condominium association included. The late Judge Maxine Cohen-Landau recognized this in ruling on a similar issue, that the issue is of ownership, and the condominium association is an owner, and they are subject to joint and several liability. In this particular case, however, and although we don't really know
how can they be subject to joint and several liability to themselves?
Well, they can. It's not counterintuitive because they are empowered to do many things. They can buy, they can sell, they can hold, they can rent. If they make that choice, which they are permitted to do, then they are making a choice to own the property or to rent it, as you will, and they're relieving a future owner of a burden. They have the choice. In this particular case,
they want us to make an exception when there's an intervening owner, right?
They want you to make an exception. They want you to find such thing as limited ownership, or that they only borrowed it and they're not responsible for the detriment.
And to do that, we would have to rewrite the statute.
Absolutely. And in this particular case, the lower tribunal apparently did. Although it doesn't say he did or he didn't, apparently he added some extra lines that would obviate the condominium association from this liability. And that was incorrect. The case law states it's incorrect, and I believe the lower tribunal was incorrect in doing so. Even somebody, I presume it's a lobbyist, realized that this language wasn't in the statute.
We're not too worried about lobbyists. Do you have any other legal argument, counsel?
The legal argument, simply, they were an owner.
So who's their recourse against? The prior owner, right?
The prior owner.
They own that.
Of course, they already foreclosed on that, on the prior owner's failure to pay the assessment, correct?
They did.
So they're up the creek.
Unless there's a statute that says foreclosure does not prohibit proceeding against an association proceeding against the former owner.
Which is what the lobbyist proposed, but was not enacted, correct?
Exactly. The statute does say they can go after the previous owner, just like we can.
They can go after, somebody can go after,
exactly.
but not for somebody who's already foreclosed on that obligation.
Well, that's a choice that they make. But the condominium.
All these are very good for you.
They're protecting themselves, and they made a choice. I respectfully request that you reverse the decision, and I'll be here for rebuttal if you need it. Thank you.
May it please the Court, Judge Stein, along with Ramon Palacio, on behalf of the appellee, Spiaggia Condominium Association. Let me make one thing clear. The definition of unit owner does not expressly include...
I'm sorry?
The definition of unit owner does not, in the statute, does not expressly include condominium association.
So what? You became a unit owner when you purchased the property at the foreclosure sale.
And get a certificate of title to the property.
Cannot be denied, Your Honor. That is absolutely right.
So what's the answer? You're saying that they could foreclose against themselves again. They can recover from the new owner as total stranger to what has happened before for the obligations that you yourself have foreclosed upon and secured the title to the property as a result of. That's what your position is.
Well, yeah.
When you say it like that, it sounds ridiculous. Well, that's because it is ridiculous.
Your Honor, the position of the Condo Association is what Judge Cortinez, what you said was that you would need to rewrite the statute. And I don't think you need to...
There's no reason to rewrite it.
Well, in order to accept our position.
It's like there's no case or controversy in this case between the Condominium Association and the Condominium Association. your position would be contrary to the entire fabric of the Anglo-American jurisprudential concept. You would destroy the entire system. Do you want to do that?
You probably would.
Well, I don't think that's the result, Judge.
You do have 5 minutes to do it.
Simple test. Your Honor, I think that what we need to look at here is we're not just focusing on subsection 1A of the statute. That statute clearly says what counsel says it says and what Your Honor says it says. However, if we read it in isolation without reference to other portions of the same statute, 18.116, then what the legislature intended was by the imposition or the ability of a condo association to impose a lien was to protect the condo association.
It's true, but they foreclosed. They used all remedies that the legislature properly gave them to protect their association. They foreclosed on the lien. It's all over.
The answer is your client did not have to become an intervening owner. And if it had not become an intervening owner and the appellant would have bought the unit outright at the foreclosure sale, you would win. And you're right. But in this case, your client became an intervening owner and, as Judge Schwartz said, foreclosed upon the prior assessments that were due.
But in order to preserve its right, it had to become an intervening owner. If it didn't become an...
life is full of bad choices sometimes.
Well,
you could do whatever, you could go ahead and keep the lien, not foreclose upon it, let the first mortgagee go ahead, go ahead and foreclose, which he did, and then go after your lien. But you didn't. You propose. It was too slow because if you're in the foreclosure division, you know that the condominium associations are always gigging the mortgagees to go ahead and foreclose on their loan so they can get their lien. And when they don't, they go ahead, as they did in this case, and take their own steps, which they did in this case.
Because
everything in this world has consequences.
I hear that.
How about that for a philosophical?
I accept that. But the consequence that we're arguing in this case is not that the condo association is left with a worthless
So you relying on the merger doctrine?
Absolutely, Judge.
You're relying on Contos versus Lipsky?
Absolutely, Judge.
Don't you feel that the dissenting opinion is much better reasoned?
Perhaps, but we have to go with the majority, Your Honor. And
don't you agree with the second district, which a year later held that the dissenting opinion was a better reason?
Well, Judge, Lassiter and its progeny, we can call it that. It's a two-step process. Obviously, I'm not making any headway in regards to the statutory construction argument. So, assuming that it is an owner, assuming that the condo association did take title as an owner, which we don't concede. Then the question is, did the condo association intend that the judgment
what does that have to do with anything?
Well, Judge, if it didn't intend, the merger doctrine, of course, is if there was no intent, and there was a merger.
There was a merger. They foreclosed, and the lien was foreclosed and merged into the judgment. Did they say anything they didn't intend at the time all this was going on?
Well, Judge, absolutely. There was things in the record that there was no intent that there be a merger. First of all, it's their burden to show that there was a merger.
In some circumstances, regardless of what your intent is, the legal consequences of what you do is what happens, is what controls, not, I committed a first-degree murder, but I didn't intend to kill anybody.
But Judge, what we're talking about is even if the foreclosure occurred and we did become an owner, and even if the law is, as all three of your honors are presenting it to be, then we have to consider whether there was a merger, because the lien does not disappear unless there was a merger.
Is there anything equitable about a doctrine which applies only if one party thinks it's good for him and not for the other?
Well, the presumption is that there is no merger, and that the presumption is that the party who has taken title, whether there's a merger or not, the presumption is that it's acting in its best, behalf.
That's legal and equitable estates.
I'm sorry, Judge, that it's...
That's combining legal and equitable estates.
Well, that is the law, as the Supreme Court has stated that it is. And in this case, there's abundant evidence in the record that there was no intent to merge. The Declaration of Condominium clearly stated that its title was taken by a foreclosure of its own lien, that there's no extinguishment of the lien. In your opinion, does it make any difference that the majority, both members of the majority in the Contos opinion are dead, and the dissenter is still alive, barely? Judge, if the law is going to change, the law is going to change. I have no power over
The
that.
dissenter is still working at it, you can tell.
Absolutely. I think that he is barely...
Not barely, barely, strongly.
Yeah.
Thank you, Mr. Stein.
Thank you, Your Honor.
Thank you.
I have nothing further.
Thank you.